Problem number 25 is that A contracts to repair his house in certain manner and receives payment in advance. A repairs the house but not according to the contract. Is B entitled to claim damages? If so, what is the measure of damages? The very problem is relating to Section 73 of the Indian Contract Act as per the provisions as relating to compensation for loss or damage caused by breach of contract. So when a contract has been broken, the party who suffers by such breach is entitled to receive from the party who has broken the contract compensation for any loss or damage caused to him thereby, which naturally arose in the usual course of things from such breach, or which the parties knew when they made the contract to be likely to result from breach of it. Such compensation is not to be given for any remote or indirect loss or damage sustained by reason of the breach. So compensation for failure to discharge obligation resembling those created by contract has been incurred and has not been discharged. Any person injured by the failure to discharge it is entitled to receive the same compensation from the party in default as if such person had contracted to discharge it and had broken his contract. So the very provision under Section 73 of Indian Contract Act is as an explanation in estimating the loss or damage arising from a breach of contract, the means which existed of remedying the inconvenience caused by the non-performance of the contract must be taken into account. It follows thus that B is entitled to claim damage. B is entitled to recover from A the cost of making the repairs that conform to the contract. For example, the cost of making the repairs in the same manner as was originally contracted with A. So, our next problem is problem number 26, and that is A makes a contract with B to wipe his horse if A survives C. What is the nature of this contract? When is this contract enforceable? So the problem is based on Section 31 dealing with the contingent contracts. The very section runs as a contract is a contingent contract if it is a contract to do or not to do something if some event collateral to such contract does or does not happen. Contingent contract to do or not to do anything if an uncertain future event happens cannot be enforced by law unless until the event has happened. If the event becomes impossible, such contracts becomes void. Thus, the contract in question cannot be enforced in law unless and until she dies in his lifetime. So, these are the 26 problems as we have discussed, and the 27th problem is that A undertakes to repay a loan of Rs 10,000 by 5 equal monthly installments with a stipulation that in default of payment of any installment, the whole shall become due. What is the nature of the said stipulation? So, as to the very provisions and the facts of the given problem, we found the very provisions of Section 74 of Indian Contract Act, which reads as, when a contract has been broken, if a sum is named in the contract as the amount to be paid in case of such breach, or the contract contains any other stipulation by way of penalty, the party complaining of the breach is entitled, whether or not actual damage or loss is proved to have been caused thereby, to receive from the party who has broken the contract reasonable compensation, not exceeding the amount so named, or as the case may be, the penalty stipulated for as it is provided under Section 74 of the Indian Contract Act, and the very explanation is that a stipulation for increased interest from the date of default may be a stipulation by way of penalty. So the very exception regarding this provision, when any person enters into any bail bond, recognize or other instrument of the same nature, or under the provisions of any law, under the orders of the central government or of any state government, gives any bond for the performance of any public duty or act in which the public are interested, he shall be liable upon breach of the conditions of any such instrument to pay the whole sum entitled therein. So the very explanation relating to the present problem is that a person who enters into a contract with government does not necessarily thereby undertake any public duty or promise to do an act in which the public are interested. Therefore, the said stipulation is not by way of penalty. This is a simple case of a contract, and the contract can be enforced according to its terms as provided under Section 74 of the Indian Contract Act. And our next problem, that is the problem number 28, and it is she agrees to appoint B as his clerk to sell goods at a yearly salary, upon A becoming surety to C for B's duly accounting for monies received by him as such clerk afterwards without his knowledge or consent, C and B agree that B should be paid by C commissions on the goods sold by him and not by a fixed salary. Is A liable if B subsequently becomes guilty of misconduct? The facts of this problem are similar to the very provisions under Section 133, which rates discharge of surety by variance in terms of contract. So, any variance made without the surety's consent in the terms of the contract between the principal debtor and the creditor discharge the surety as to the transactions subsequent to the variance as provided under Section 130 of the Indian Contract Act. So here the variance is made in the terms of the contract between B and C without A, who is the surety's consent. A is not therefore liable for the subsequent misconduct of B. And now we'll go to the problem that is the 29th problem, and that is A has a carriage of B. The carriage is unsafe, though B is not aware of it. A is injured. Is B responsible to A for the injury received by him? So the facts have been taken from as relating to the provisions of Section 150 of the Indian Contract Act, which reads as follows: Bella's duty to disclose faults in goods billed. The beller is bound to disclose the belly faults in the goods billed, of which the beller is aware and which materially interfere with the use of them or expose the belly to extraordinary risks, and if he does not make such disclosure, he is responsible for damage arising to the belly directly from such faults. If the goods are billed for hire, the beller is responsible for such damage, whether he was or was not aware of the existence of such faults in the goods billed as it is provided under Section 150 of the Indian Contract Act 1872. So B is therefore responsible to A for the injury as the carriage was billed for hire, even though B was not aware of the defects in the carriage. So almost we have completed 29 problems relating to law of contract with their appropriate answer, and as we solved all these 29 problems, and in our upcoming video would like to discuss some other relevant problems as we framed under the law of contract, and that we would like to discuss in our upcoming videos.